firearm regulations are boiling over here in Nevada. My resident attorney here, Don Green, has been doing research on this and has some comments on some of our wins and some of our losses in this pro-self-defense and pro-Second Amendment rights fight. Don, I'm going to turn it over to you and charge on.
Thank you. Thanks to a number of concerned citizens, both at gun shows, people who are talking to other people at at gun stores, people who are meeting at coffee shops all over the state of Nevada, from the Saddle West and Pahrump all the way up to the Pioneer up in White Pine County, all the way up to those little coffee shops in Sparks and Lander County. All of these people need to be congratulated for this this grassroots movement, which has prevented the following. In Nevada, we will not have a good cause requirement for new concealed weapons permits or renewals. That's been part of the big fight in California, especially the Peruta decision back in June of 2016, which went all the way up to the U.S. Supreme Court, which refused to hear that. And that was whether or not the good cause requirement under the California Penal Code was constitutional as a violation of the Second Amendment. The Ninth Circuit, being a very liberal court, said, number one, there is no right to a concealed weapon permit under the Second Amendment. We agree with that because in Nevada, we don't have to worry about that Second Amendment. We have a statute. So the good cause requirement is not the law. Second, the current concealed weapons requirements are unaffected by the 2019 legislation due to effective lobbying. There were some things that were going to be changed and proposed early in this legislative session and promised by Democrats well into 2017 and, of course, as part of the 2018 general election. Next, we're not going to have a magazine ban in Nevada as they do in California. Now, although the California magazine ban is right now under a restraining order, which Judge Benitez in San Diego federal court has kind of held off on his order pending further adjudication by the Ninth Circuit up in San Francisco. So we don't have a magazine ban in Nevada currently. And unless there's something extraordinary, which happens perhaps with cities making their own bans, we're not going to have one anytime soon. Next, we do not have an assault weapon ban in Nevada. So everyone should be very thankful about that, and people got the message out. And a lot of people were saying, well, what can we do? Well, you start talking to people. You call your legislators. Even if it's a Democrat, just call them. They may not listen to you, but the word got out. The fifth point is that we still do not have a statewide gun registration, but there are possibilities that there may be registration now left to municipalities under the anti-preemption law, which would allow municipalities to literally enact ordinances which might affect both the ownership of guns and registration of guns. Next, we don't have any restrictions on ammunition purchases or sales. Now remember, in California, starting this year and starting next year, this is when there are very severely restricted ammunition sales, including, but not limited to, background checks for ammunition purchases in California. Let me repeat, background checks for ammunition purchases in California. So what does that mean? Are people going to come to Nevada or other states like Arizona and purchase their ammunition? Well, it's quite possible. Is the California Highway Patrol going to sit across the border right there in Primm, Nevada and check you out? We don't know. But right now, we don't have that problem in Nevada. What's the bad news? For some people, it's bad news. Other people, it's marginal news. And in this special report, we have to advise you of the following. We have a bump stock ban in Nevada. My response was, who cares? Because the ATF regulation, which started back in December, preempts Nevada law anyway. And the Bureau of Alcohol, Tobacco, and Firearms issued proposed regulation in December of 2018. Now, under the Federal Administrative Procedure Act, under Title V of the Code of Federal Regulations, there must be a 90-day notice and comment period. That period ended in March 2019. The regulation is law. The bump stocks are now illegal because they constitute a National Firearms Act weapon, as making a weapon an automatic weapon, which is kind of ridiculous because they backtrack on what the original configuration, what the original approval for the configuration of bump stocks was back in the Obama administration twice. And those were to assist handicapped or disabled users of weapons. Now, the bump stock ban is subject to legal challenges by the right person. Just because you own a bump stock isn't going to make you the right person. However, there is the issue of the taking. Is now this an illegal taking of property without just compensation? That's the precise argument made by a company in Houston, Texas, about 2 months ago, when that company filed a lawsuit, not in Texas, not in federal court in Texas, but they were smart because they filed a claim against the United States in the United States Court of Federal Claims in Washington, D.C., which sits without a jury and is very well known for siding with the government and going against the government in appropriate cases. So in Nevada, with a lot of people saying, well, it violates my Second Amendment right. Well, there's virtually no possibility of a successful Second Amendment challenge to the bump stock because the bump stock does not change the ownership of the weapon. It only changes its physical characteristics in assisting the shooter to fire the weapon, which, and Bob has demonstrated this on a number of shows through references in the movies and references in television shows, that weapons can be fired much more rapidly by proper training or by improper training. Now, will there be successful challenges to the bump stock law regulation in Nevada? Well, it's twofold, because even if you win in Nevada, you still have the ATF regulation, which prohibits it, and under the supremacy clause of the Federal